Yeah, first of all, thanks a lot for taking the time to do this. Um, I'll get right into it. Can you elaborate on what kind of information it is that WhatsApp seeks to share under the new policy?
Sure. So let me just first clarify that which a clarification has also come from WhatsApp itself.
Mhm.
We are not talking about the content of the message. So, for example, you, Aditya, pinged me, Mishi, on WhatsApp, and you wrote certain things in the message. Let's schedule for this interview. Let's try to talk about it. Now, whatever you wrote in that message itself is protected by end to end encryption. Nobody, including WhatsApp, can actually look into what has gone in that message. So if somebody were to ask, like if a police officer came up or your boss came up or mine who wanted to look and ask WhatsApp, what did they write to Mishi? We would like the content of that message. So WhatsApp, like, well, they are end to end encrypted. So I can't look into it. So what are you talking about? Now, because it doesn't have access, and that encryption is the same encryption which other strong apps like Signal use. That means content will never be able to read by WhatsApp. Now, what happens, and when you ask what is the information which is actually exchanged, or why is this entire brouhaha, etc., which is happening? Now, so Facebook, um, uh, it's this conversation, but WhatsApp, unlike other messaging apps, does collect metadata. Now, what is metadata is far more useful for any such business which is trying to provide or make a profile of a person than the content of the message. What you and I talk about, whether the cricket match was good or not, or I had a bad day, etc., it's not important. What are they going to really do about that? But who you are, what is your phone number, who are the various people you contact in your list, or how long do you speak to them, what is the device you used, and this all information is part of metadata, and that's important. A lot of times we are told that this metadata, which is data about your identity, that is less than data. Often that's not correct. It is actually more, because your mobile number and your profile information is far more valuable and more dangerous to you, but for more valuable to the businesses. And that information is thereafter used and to build a profile, and also to share between the various companies which the Facebook conglomerate has. So that's the major part of it. Now, the other point I would want to insist is that it is true that the sharing of this data has been continuing from 2016. So Facebook acquires WhatsApp for $22 million. They changed their privacy policy, which neither of us, nobody bothers to read because it is too complicated. And there is an update in 2016, and which tells you what is happening. But there were 30 days which were given to people to opt out if you did not want WhatsApp information to be shared with other companies or Facebook. If you missed that window, or you were not using it in 2016 WhatsApp, you came to the party later, then all bets are off. Now you've lost it. So, so what has happened is people never noticed that such a thing was going on. And some of them had missed that window. Some of them were never using it. So right now it has been clarified, because usually everything is wrapped and written in different and difficult legalese or jargon which people don't understand, because everybody scrolls and just says, I accept. So it has been clarified what they've been doing since 2016, and they have added a few more changes. But it is true that if you were to see the privacy labels of what different apps do, a Signal only collects your phone number, but WhatsApp collects a lot of other things about what you do. So nobody's looking at the content of your message, but they're collecting a lot of other information. about what you're doing on the app.
And how do you think this goes against the Puttaswamy judgment, where it was held that informational privacy is a facet of the fundamental right to privacy?
Right. So now the judgment is an interesting thing, and from my point of view, the judgment opens the door for development of more jurisprudence in all of these concerns. So obviously, that because when we talk about fundamental rights, they are only justiciable against the state. And so about that, there is obviously clarity, and you can rely on a whole body of case law, which the judgment itself relies on. Um, and because of that, you can see that it is easy to understand that what is the standard which has been established, where any time an invasion of this right of privacy happens, then the court says, okay, here is the standard. This is the standard you'll have to use to evaluate whether this is something which is necessary, which is proportionate, which serves a legitimate state interest or not. It does talk, as you rightly said, about informational privacy. It talks about various facets of it. And it opens the door about examination of how all of these things will play out in our current scenario. Now, because there is a development of the data protection bill, which is a necessary but entirely inadequate step to protect privacy, we are all right now in that mode of figuring out what the law would be. And because legislation will also then have to be tested against this judgment itself. So I would say that right now, there is a lot more scope for development and clarity about what exactly are the guardrails on such developments. So if tomorrow you were to say, oh, whatever Facebook is doing right now is a problem and WhatsApp sharing is a problem because of KS Puttaswamy, no, there is not a clear thing which we can establish right now. We'll have to go, we'll have to develop it. And because there are all these other considerations, also moving parts are there are too many variables. We are right now on that path to see what will be the data protection bill, what kind of data sharing will be allowed or will not be allowed. And courts don't legislate, obviously. So this bill has been pending forever. So once we see and have more clarity, not only with the bill, but what all other kind of regulation this bill will cover, then we would know where we are. Right now, everybody's beating the same dead horse of the IT Act. And there's always this confusion about how far can you actually go to tell a private business how can they run their own business and platform if there is no clarity which we have given in terms of what are the limits here, and we don't have any limits here.
You mentioned the personal data protection bill. What do you think are the shortcomings of the bill in its current form in terms of securing data protection and privacy?
So because, as you know, that the bill has been in the making forever.
Yeah.
For last 2 years, it's been pending in the parliament. It was tabled, and then the JPC started holding hearings.
Yeah.
Thereafter, they also added a non-personal data framework. So currently, nobody knows what is the actual form which is under consideration here. When we started with the report, very beginning, when we start that there's a report, then there was a bill which was presented to MeitY, and that time, at least it had very exhaustively covered quite a few of the principles which are now accepted as global best practices. And the gold standard here usually has been GDPR, but since then, California has come up with CCPA also, and various states in the US are coming. With this new administration, we know that an omnibus national legislation is going to happen in the US as well. So a lot of things have improved, but so far, something which is working, which is being enforced, is GDPR. So against that, there were a lot of good things in the bill. There were problematic areas like data localization issues had not been addressed. There was a lot more other issues which people had been addressed. But each time we've seen that the new version changes. And with this new thing about trying to make an artificial distinction between personal data and non-personal data, and somehow monetization of that data by the community, this has now put a monkey wrench into the development again. So I would say it would be disingenuous to say, oh, these are the things which are wrong, because we don't even know what is right now tabled. And JPC has held a lot of hearings, but they've invited everybody other than, I would say, I've heard civil society members. So I don't think that it has been shared publicly. So I can comment on older versions, but then that would be moot for now, because perhaps they don't exist anymore. The one important thing which I would say is that India is a country which has great tech potential and is obviously a major market. But one major thing which is missing from our jurisprudence, starting from whether it is Shreya Singhal or K.S. Puttaswamy or various other laws which we currently have, whether under the Telegraph Act or IT Act, we have been in for a surveillance reform for a very long time. Unlike most other countries, we have no judicial oversight. We have no parliamentary oversight over how surveillance is being done by our own government. Everything is left to the executive. So executive itself issues orders, and then there is a committee by the executive who reviews those orders. And there is just really no way for us to have any information about what surveillance is happening. So we need a legislation and we need complete reform of how surveillance is done. It can be done for a lot of purposes, but we have no clarity. We don't have any oversight. And that's a major part of the data protection bill also, which allowed government agencies to do whatever they would like, which is obviously not keeping in times with the modern times. It also is not justifiable in terms of how we look at the Universal Declaration of Human Rights framework. And we have already seen that there is very close data sharing between what government is collecting and then sharing with private parties. So if we have to protect people, we have to have surveillance reform with parliamentary or judicial oversight built in.
And you see that there have already been a number of petitions filed in various courts challenging the policy. Do you think it's within the realm of the courts to step in and do something, or what is your opinion on that?
Yeah, that's an interesting thing. I think what is happening is that because the government has been dithering for so long, and because there is really no clarity about what is our overall framework for innovation. On one side, we want digital India, make in India, make it a Silicon Valley kind of thing. On the other side, we want to control everything, right from what you watch on an OTT platform to how you share data and everything. So those two forces are constantly pushing against each other and pulling also away from each other. And courts seem to be our only resort, unless when there are serious litigation, if it's not a publicity interest litigation. But when there is serious issues, courts seem to be our only resort where we all go to and at least hope that some action would be taken. There has been, starting from the Madras High Court, now there's been a pending matter in the Supreme Court for some time about traceability, where it started with, oh, let's link social media accounts with the people's messages, which is a totally disastrous thing. Again, with WhatsApp messages also. We've had enough of research that doesn't address misinformation, disinformation. Now, having said that, technology is hard. And even users like us, who perhaps are natives with technology, take time to adapt to a lot of things. And law is slow. And suddenly you expect all these judges to know every little detail about how technology works, balance innovation, balance the fundamental rights, and also ensure that the government can have access to all those catch-all phrases of national security and everything else. You're putting them in a very difficult place. And that's why these kind of observations come from the bench sometimes, which are arbiter, but they also find a way in judgments later, which are not entirely accurate, and that's not how tech works. But tech is always 2 steps ahead, and policy is in the middle, and law is 2 steps behind. So now you're putting them to say, oh yeah, do all of these things because we can't figure it out. That's why, like, we had one observation in the WhatsApp traceability case in which the Honorable Justice said, oh, if you can figure out this technically sophisticated way to encrypt end to end, you must figure out another way also. So he's talking common sense, but unfortunately, math doesn't work differently for good guys and bad guys. You can't say today, oh, this police officer is only doing it for catching crime, so let's allow him to break encryption. Because once you break encryption, then you are allowing all the bad actors also to steal all your data. We think of encryption only in terms of these chats, but that's not the thing. India prides itself on banking. All your online banking will not happen. All your e-commerce will not happen. Various ways of how even companies or government secure data, none of that will happen. So it's not just this, it's really making our lives possible the way we have. And especially in the pandemic, I think people who were earlier hesitant to explore tech have also learned how important it is and how useful it can be. And none of this is going to work if you do that. So I would say that as attractive as courts look as a forum to adjudicate on these matters, we are asking a lot from the judges. And thereafter, we are letting our own government off the hook. And we are not coming up with comprehensive policy, which decides whether we are light on regulation, whether we like self-regulation, whether we want to just establish some broad frameworks, or we would like to very closely monitor and control. So that comprehension in how a policy for the country should be decided and is lacking. And this knee-jerk techno-solutionism for everything, let's just solve by making an app, doesn't work. And every time rushing to courts just puts unnecessary burden on matters which require long-term thinking.
Can we draw parallels to between this, what's happening in India, to what has happened before in some of the European countries or the US? Is there any situation that existed before this?
So parallels, I would say, but obvious because these are there might be certain commonalities, but these are very different countries.
Yeah.
I only practice law in the US and India, so I only am familiar deeply with these two jurisdictions. Europe, obviously, we followed very closely because of the development of GDPR. But I will say that US for a long time had a laissez-faire approach on many of these things. Privacy, whatever. And privacy was examined in the form of personal rights for abortion, for searches and seizures, etc., like the Fourth Amendment. So, and the American platform companies also had the advantage of a robust free speech system in which we examine the content moderation. What they take down, what they do not take down, they've all been thinking about it from the First Amendment point of view. Then Europe, which really does not have many innovative new companies, thinks about it that, oh, but they do have very, very strong regulatory structure and laws. The European Commission really works. And they understand that people's rights have to be put in the center. And historically also, their content moderation is not as open as the free speech in the US has been because of a history of fascism. And of course, the Holocaust, which people in Europe are suffered far more, and they knew what misinformation, disinformation, and propaganda can do. So they control it far more deeply and carefully. And that's why they were the first to come up with a lot more control, whether it is about antitrust litigation or it is about GDPR, and now the Digital Services Act also. Then there is China, Russia, or Iran, who just want to keep everyone out and develop their own products. so that they can completely control those companies and rights really don't matter. And India, which cannot decide where it wants to go, and is still being pulled in one direction by Indian companies who know that they have missed the bus on innovation, but they also know it's a really attractive market in terms of data. So they would like to monetize that data. So they are forcing the government to say, oh yeah, give us control about our people's data. But that doesn't make you a great player in terms of trade, a global trade. And India is a democracy. So it really cannot go the China, Iran, Russia way. I mean, Russia is, you can decide what it is. So I would say, but what we have seen is a very robust civil society conversation in India. What we have seen is a lot more interest in understanding that we do have an advantage of a great technically sophisticated population in India. Not only the market is good, but we are also the people who can provide better products to the rest of the world. So there is a lot we have which we can monetize by producing products which can be everywhere. In terms of law, I would say that the last draft of the data protection bill, which we had seen, did draw a lot on the principles of GDPR. Not entirely, but a lot on that. And so there is somewhat there, but please be mindful that enforcement is the key here, and nobody cares. How does it help me if the CEO of a company is put in jail for a data theft? It's not going to change anything. It just creates a lot more barrier for innovation and for people who are running businesses. What we want is swift, quick enforcement actions, but which impose large fines like GDPR does, 4%. And that's what we saw also, somewhat of it, but we don't know where we are going right now. So if what we are seeing the trends are, the trend is that put people in the center, because people are tired of all the data theft and they would like a simple way for addressing all of these issues. Put people in the center, have clear rules, have transparency in policies, force companies to tell what they're doing in simple terms, and let's proceed from that. So that I would say, have the law, start with the enforcement, but think of it in form of framework. Not think of it, oh, we have data protection law, everything is taken care of. We need a lot more education for digital security, and humble education, not looking down upon people because they made a mistake. It is complicated. And so we need a lot. That's why thinking of it as framework. Have the law, have clarity about enforcement, and try to avoid years and years of litigation, because now we are dealing with something which travels much faster than we have ever seen anything travels. And months and months really don't help anybody unless we have swift enforcement of it. More education about how to secure yourselves, how to secure your own companies as well as your own organization, and an ability to develop more regulation or self-regulatory mechanisms as we observe how the market is reacting. Instead of taking 5 years to come up with a basic legislation, to keep watching what we want to do, decide on principles. These are the 5 principles we would like. We want India to be innovative. We are not interested in controlling what you watch in your bedrooms. We are interested in protecting your privacy. We would like to have control when there is a requirement for a criminal investigation, etc. Those kind of 4 or 5 clear, simple principles, and then draw your policy on all of that for everything tech, and keep it light enough so that it doesn't take 5 years for us to do it, and think of it as a comprehensive framework. And I can't insist how much transparency matters here, whether you're a WhatsApp or a Facebook, or you're the government, or you're anybody. If you're going to lie to people, or you're going to try to be clever by half, people are going to find out. And then you will lose trust in the product. And which is for the companies, and that is not good for the business, and also is not good for a democratic government to not be able to win the trust of its own citizens.
Right. That's all I have. Thanks so much for your time.
Subscribe to our YouTube channel and click the bell icon.